You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury, and happy Freedom Friday. We are back with another policy breakdown episode, and today we are joined by one of my favorite humans and just a master in the space of public defending. Today he's going to highlight the main issue that surrounds public defenders, and it's the question that every single public defender and quite frankly any criminal defense attorney is asked, and that's: how do you defend the guilty, the rapists, the murderers, the indefensible? And if you're not in our unique positions to get to learn these individuals, hear about their stories, look at the legal aspects of their cases, we understand why we get asked that question so often. But until you take the time to listen to our answers or experience the day in and day out life that we live, few and far between will be able to truly understand the magnitude, which is being a public defender, which is going against the government and standing up against their power and being the voice for mostly the voiceless. Specifically, as public defenders, the bulk of our clients are going to be those who are poor, indigent, and most likely from a minority community. And so it increases the battles inherently in a criminal defense case where, although the Constitution gives us the presumption of innocence, it definitely feels like you're guilty until proven innocent. And it's because of our profession and the individuals like our guest today where we see success, where lives are saved, and a better criminal justice system is implemented. And so I can't wait for you all to hear from him and have him break down the intricates, the ins and outs of public defenders and why it's so important that we exist and that those who are charged with crimes always have that protection. Joining us today is my friend and fellow Deputy Public Defender, Jason. Jason, please introduce yourself to the members of the jury.
Good morning, and Lucas, thank you so much for having me. It's a real privilege to be here. My name's Jason. I've been a deputy public defender essentially all of my career as an attorney. I love it. I plan on continuing to do it until I can't do it anymore. And for all I know, that's until I'm ready to retire. When I'm not public defending, I am big into mock trial. I am coaching two teams right now, a law school team, a high school team, and I am teaching a trial advocacy class. I might have taken on a little bit too much this semester, but I love my work in public defense. I love the courtroom, and I feel very fortunate to be able to have the opportunity to have this career path. So thanks again for having me.
Well, thanks again for joining us. I definitely know that you do have a lot on your plate and you are impacting so many different lives this semester, whether it be in your day-to-day job or in the after hours where you're helping law students and high school students find their passion and develop their skill sets to hopefully groom the next generation of public defenders and trial attorneys. You know, Jason recently had the privilege and the ability to speak on a TedX talk, specifically about the topic of defending the indefensible. And Jason, would you give us an insight into why that was the topic, or what were your initial thoughts when you heard that that was going to be the topic you were asked to speak on?
Sure. So I've been coaching the high school mock trial team for, I think, 5-6 years or so. And the students are always very interested in the stories about my work. They host a TEDx talk at the end of their school year every year. And the committee that runs it's a little bit of the mock trial team, but it was actually other students who had just maybe heard me speak at the school or talk about the mock trial program I had given a lecture on the Fourth Amendment at one point too, and they said, "Hey, your job sounds interesting. Why don't you come to this TED Talk?" And the TED Talk was about the importance of community and welcoming people into a community, having people be a part of the community. And they said, "Well, why don't you just come in and tell stories about your job?" And I was trying to think of a way to integrate that because typically most people do not want those charged with crimes in their community. They are scared of people who are charged with crimes or have a criminal history. And I thought maybe one of the best things that I could do is tell a couple stories about, I think, people that you would not be scared of, or that even if they were guilty of the crimes, you would still want to defend them and care about them and want them to be a part of your community. So that was kind of how the topic had started, because that's one of the things we get asked the most is how do you defend someone who is guilty? And having done this for so long, and I'm sure you know, Lucas, I mean, most of the clients are, it's not that we're going to trial 9 times out of 10 and taking everything to the box, although some years it feels like that for sure, where I'm litigating a lot more than I was expecting. But generally, we're trying to find a resolution to the case, or maybe we're taking the case to trial, and the evidence is still very strong against our clients, but for whatever reason, we're not able to come to a resolution. And there's definitely times when that's the right thing to do too, when maybe the plea bargain or the punishment is unfair, or maybe there is no plea bargain at all. And we find ourselves there at trial with a case where it's an uphill battle. So that's how this topic had come up. And I thought I will share some of my experiences and a couple stories with the students that sort of fit into that topic of the importance of community, welcoming people into your community, the importance of including people in your community.
Well, I think it was such an important video, and for the audience listening today, it will be attached to the show notes. It's about a 15-minute TED Talk, and I highly encourage everyone to listen to it. Jason does an outstanding job highlighting really the importance of not only public defense, but criminal defense as a whole, and I think he uses 2 different examples to do it beautifully. One of the examples is, just as he was alluding to, it's on paper and legally it looks as if a crime had occurred and that an individual may be quote unquote guilty of it. But that doesn't necessarily mean that that individual or set of circumstances should result in a conviction, or that there was a lawful means to the discovery of that unlawful conduct. And so he highlights the importance of our Fourth Amendment, the abilities for lawyers to challenge the lawfulness of a stop and the collection of that evidence, because no person, even if they are actually guilty of a crime, should be convicted of a crime if the evidence was collected unlawfully. And that is a conversation that I have with a lot of different people, especially law enforcement, who almost are quickly to kind of put the Fourth Amendment on as an afterthought, because they're so focused on getting the bad guy or getting the conviction. Jason, in your time and experience as a public defender, how do you deal with that kind of consciousness of, yes, technically he may have satisfied the elements of a law, but the only way we got there was from an unlawful search? How do you personally deal with that?
A lot of times you'll talk to people and they'll ask you, how did you win that case? Did you win it on a technicality? And I think initially they have this idea that it's something that is almost like a loophole in the contract. It's like I found something in there to get my client out of trouble. But I think when you get into the nitty-gritty of it all, and you start to see what had happened in terms of police unlawfully searching someone or stopping someone, and you really learn the details of it, people stop seeing it as that technicality and they see it as a human right, one of the most important human rights that we have, which is to be free from unlawful treatment from the government. And it comes from so many different angles, things to racial disparity and how essentially, how poorly minorities are treated by the police and stopped and profiled. And so as you get into the details with people, I find that they see that this is not so much a technicality or a loophole. It's something very, very important to fight for. So you just have to have as much information as you can, and you get into the facts of the case and you see, you know what, we have to fight for this. We have to stand up for this. Even if the person did something wrong, it's what's more important are our rights, and someone has to fight for them. So knowing somebody is guilty, the example I used in my TED talk of a possession of a dirk or dagger, a very interesting crime. And it was certainly worth fighting for that. But there have been cases where perhaps I've had stolen property suppressed or quantities of drugs that were being used for sale. And I understand that people don't want someone stealing someone else's property to have their case dismissed, but we have to protect our human rights, our rights against the police. We can't have people being unfairly targeted because of the way they look by law enforcement, or stopped or mistreated, even if they committed a crime, because you'll start to go down that slippery slope. And so we have to protect it every step of the way. And it's not that easy either. And it's not something that happens often. I can't say that I win most of my motions to suppress evidence for unlawful police conduct. I've certainly lost a lot more, but when the time is right, we have to do it. And it's a very, very important right that we have. And if we don't protect it, I don't know who else is going to. That's our job. That's the point of the criminal defense attorney in the criminal justice system. They have to raise that issue.
I just absolutely loved that example from the TED Talk because it really resonated with me and what I've come to structure as my answer to that question that we get is, how do you defend the guilty? And what I've come to develop, and I think that it gets pretty good response, is that so many people think it's our role or the criminal defense attorney's job to, find the technicality, and the sole purpose of our job is to, get our clients off or get that not guilty. And through my time as a public defender and my experience, I've reshaped that. Obviously, that is a great goal and a desirable goal. But at the end of the day, our job is really to be safeguards of the Constitution, to be safeguards that all of the major players who are potentially striving to strip away an individual's freedoms and liberty are playing by the rules and obeying the laws. We're there to ensure that the police do their job correctly, that the prosecution are doing their job correctly, and that the judge are doing a fair and impartial job. And if that ends with a positive result for our clients, well, then that's great. But I know so many public defenders and criminal defense attorneys who do that, who ensure that their client gets a fair and safe case, trial, resolution, and it ends with a conviction. It ends with a prison sentence, but they're able to hold their head high because they feel confident in what they were able to secure a fair and just result. I want to ask, in your time as a public defender, in the decade that you had, have you come to your own specific short answer as to when you're asked that and confronted with that question, how do you defend the guilty, without having to, go into a 15-minute TED Talk just to really explain our position?
Sure. And to give the short answer to most people, I talk about how backwards our sentencing laws are, how racially discriminatory our certain crimes are. And that's basically my short answer. And sometimes I'll tell a person what they are facing, and they're shocked to hear how much time it is. One of the more racially discriminatory crimes I used to have was possession of cocaine base, or possession of crack cocaine, essentially, and it was a mandatory felony for years, whereas possession of methamphetamine was not. And people couldn't understand that because Well, somebody on the influence of methamphetamine can be quite violent or dangerous, but let's look at it from the big picture. White people like methamphetamine, and it was our African American communities that were using the crack cocaine or cocaine base. So why can't one be a misdemeanor as well? But that was the law for years. So I just give people a short answer of, you would not believe how unfair or how discriminatory some of these laws or mandatory minimum sentences are. So I will gladly defend somebody very guilty because the punishment does not fit the crime.
How do you combat that when you know that you are looking at a case where you have a client who's, as a public defender, fits into one of the main categories of poor, indigent, homeless, person of color? When you're facing that type of case, and you know that historically and statistically that this person could be exposed to an unfair, unjust resolution, how do you combat that to ensure that they do get that equal and equity setting in the criminal justice system?
Well, I call it when I see it, and I do not hesitate to bring that up to the judges, to the prosecutors, and that could be from our very first time trying to negotiate the case. A good example these days cases I'm finding are the pimping and pandering cases, which are mandatory state prison. Mandatory with you cannot get probation on even a pandering charge. Just to specify what the difference between pimping and pandering is, pandering would be just encouraging somebody to get into an act of prostitution, whereas pimping would be you know that they are an actual prostitute and you're receiving sort of the benefits of their income or the money they make from prostitution. But if you had no criminal history and you're 40 something years old and you're convicted of either of those crimes, it is a mandatory state prison sentence. So I do not hesitate right out the gate to say this is such a racially discriminatory crime. And a majority of my clients who are charged with these offenses, the conduct is extremely minor and they're African American. And I do not hesitate to point that out. I try to do everything that I can in my power to convince the judge or the prosecutor that this is the crime does not, or the punishment does not fit the crime. And then if we have to, we go forward and we fight the case tooth and nail as much as we can. But I think you have to raise that issue very early on and just put it out there and call it for what it is, because I may represent a white client who is somehow getting a probation offer on a 288 crime, which is a lewd act on a minor. And the one I'm specifically referring to is kind of that old TV show, How to Catch a Predator, where you would have someone pretend to be a minor through either a chat room on a computer or text message, and they would pretend to be underage, and then they would trick the adult into meeting up with them at some location for some type of sexual activity. And I was able to get probation on those cases, and the law allows me to do it. Now, you tell me, which one do you think is worse? Someone encouraging somebody, say just through chat rooms or text messages, encouraging them to act as a prostitute, or someone going to meet who they think is a 12-year-old, going to that actual location, say with food or gifts, finding out it's really an undercover detective? Why does that person get probation? So I call that out right away when I see it. And I find that it just address the issue head on with the opposing side, with the bench, to just bring it into clear picture. And I make those comparisons and contrasts all the time. And I said, can you please explain to me how this is fair? And sometimes the answer I get is, well, Jason, that's just the law. Well, it shouldn't be. So we have to try to find a way to work around that is fair. And if the case is so bad that it's not something worth taking to trial, we have to find a type of punishment that fits the crime. But that's the one that lately, at least, has been boggling my mind, which is, how does this type of a crime legally get to probation and this other one doesn't?
I think that's such an important issue to highlight and combat, because you hear it all the time. somehow in 2022 that people think that racism and racial inequality no longer exists. And one of the biggest things they like to argue is, well, can you show me a racist law in the books? And obviously in 2022 and over the last several decades, legislators have enough education and common sense and wherewithal to no longer objectively write racist and bigoted laws into the books. But how you just highlighted how there are certain crimes that are focused on or punished more harshly, how just because of those are you able to end with it being a component of racial inequality?
Well, I sure enough, as you can imagine, if I point that out, I mean, I get pushback from the opposing side that's not the basis for it. That's just the way that the laws are enacted. So I don't want to say it falls on deaf ears, because I do think that they at least listen. But we have to kind of come up with some sort of a creative way to resolve that case where it just doesn't involve that law. I don't know if I'm always able to do that, but I have to really demonstrate and show them who this person is in order to somehow get there. I mean, if we have to take the case to trial, we have to fight it all the way. Sometimes that's the only solution. So it's one, we have to come up with a different kind of a law or change the law somehow, I think, to get to a fair resolution if the case is going to be plea bargained. If not, if we cannot come to an agreement, then trial is the only answer. Of course, when you get to that point at the end of a trial, if you win, great. If you lose, how tight are the judges' hands in terms of their flexibility? And I always believe wherever, there's a will, there's a way. And there's plenty of times where I've gone and I've just taken a case to trial because the plea bargain has been so unfair that we did not have a great case to try. We lost, but somehow we received a much better sentence after all was said and done and the evidence was presented. So there's a time and a place to do that as well. And if we have to do it the hard way, that way, we will do that as well. Sometimes we're able to circumvent that before the trial starts when we're assigned to a trial judge, and the trial judge just hears sort of a summary of what's going on and reads an earlier preliminary hearing transcript and decides, you know what, I think that this is a fair resolution. Throughout my career, I was finding that was happening less and less, but there's certainly points where by the time we're on the brink of trial and we're ready to go, I explain sort of, the racial inequalities in the case to the judge, and the judge says, all right, you know what, I think that this is a right outcome, despite what the prosecutor may think, and they can argue their heart out. But the judge will say, no, I think that this is a just outcome. So sometimes, Lucas, we're able to figure it out earlier on, and sometimes we are not, and it has to go all the way through to trial. And my hope is eventually, we get there one way or the other, whether it's a guilty verdict and a fair sentence or a complete not guilty, which that happens sometimes on a case where the evidence is very, very strong. Excuse me. I've had plenty of cases where I've gone to trial and we've offered a lot of time to the prosecutor, and they've just said, no, we don't want to take that. I have one in my mind in particular when my client was facing about 20 years, and we had offered 8, and they wanted 12. And we went to trial and was found not guilty, and they got nothing. I had another one where the client was facing life in prison, and we had offered, I think, 12, and they turned that down. And then we ended up getting 4 after trial, and on a very strong case for the prosecution. So, that happens quite a bit as well. And I think to circle back to one of the things we were talking about defending a guilty person, I never really know I never really know what happened. I've been doing this long enough now that as much as I may think I know everything, I really don't. And I have a client that I represented years ago, which really taught me this. He went into a 7-Eleven that I actually lived nearby, that I used to frequent often. And he would help himself to things inside the store. He would take water, he would take Cheetos, he would take soda, he would take coffee cake, ice cream, and just kind of walk out and leave. And the staff grew to hate him and want him out of the store and chase him out of there. until one day he was charged with a robbery because he was accused of trying to take a swing at the manager and hit him in the face, and then take a flaming hot Cheetos bag or something along those lines. When I got in the case, the client had insisted to me that he was being racially profiled by the staff. He did no such thing. The manager hated him and yelled racist slurs at him, and had actually tried to drop kick him, like jump in the air, karate style, and kick him. And so naturally, I investigated the case. I obtained the video surveillance. It did not show anything like that. The video surveillance I had, there was no audio, so I couldn't confirm any of the racist remarks. I didn't necessarily doubt him, but the drop kick, I said, I don't really know. I said, I talked to the manager. He was about 55, 56 years old. He didn't seem particularly nimble. And so he had testified at a preliminary hearing. It did not go well. We were post preliminary hearing and getting ready for trial because the plea bargain was a lot of time. The prosecutor had wanted my client to go to prison for several years and have a robbery conviction. And he was just a young kid. He was only 25 or 26, but credit to one of my investigators at our office who ended up contacting 7-Eleven corporate, and separate from the individual 7-Elevens that have their own video surveillance, 7-Eleven corporate out of Texas has their own cameras. And she ended up obtaining those through a subpoena. And we ended up getting different video cameras from within the store that the store manager had no access to. Probably could have gotten for us, I guess, if he really wanted, but he didn't have access to it. And so we got it from corporate out of Texas. And sure enough, in the video, there I see this 55-year-old man as my client's just standing outside, and the two of them are yelling at each other. I don't know what they're yelling. He actually jumps up and drop kicks my client, and he's 55 years old. And I go in and I said, well, you were 100% correct. And I could imagine what racial epithets this man was using against my client and saying to him to agitate him. And then after he had drop kicked my guy had gone over and yelled at him and then pushed the glass doors at him. And then afterwards he went inside and he took that bag of flaming hot Cheetos out of principal because he was upset he had just been drop kicked. So I showed that to the prosecutor. They offered a plea bargain of just a petty theft to my client. He was released from jail immediately that day. And we did not go to trial, but going back to what I'm trying to say here, I don't question anything anymore. I may think somebody is guilty, and I may not think it's a very good case. I may not think I'd be able to prove it, but I really have no idea what exactly happened because I was not there. And that's just one example of many where I could not believe what really transpired. So I will gladly take a case to trial. And if my client's telling me that I was treated unfairly because of my race, and perhaps someone jumped in the air, middle-aged, and somehow kicked me in my upper body, it's not out of the realm of possibility, Lucas. So I will gladly go forward and defend it. Whether or not I can prove it, well, we'll see. But I'm going to do my best, and I can't say I 100% doubt that it happened.
There was a lot of gold in that answer, and I think the thing that resonated with me most and what actually connected to the second example that you used in your TED Talk was the importance of investigation and the importance of getting to know your clients, who they are, where they come from, what their background is, and how that can then play a role. I think you also talked about with one of the things that I say to almost all my clients is, look, at the end of the day, you being the client are going to know the most facts about what actually happened as far as it relates to the truth. What we're privy to are only what's put in the police report or what's testified to. And you're absolutely right that there's always so much more to the story than necessarily what's originally perceived. And that connects to almost all of our trial breakdown episodes, because in almost every single one, we have a what the fuck moment where there was some new fact or some piece of evidence or some different perspective that just came out based on the way that the trial was going that just wasn't on the radar going into that trial. And so I thought that answer just provided so much gold of information. And I actually want you to follow up with that component as it related to your second example, where you have a client where you knew that as far as the elements of the crime were concerned, it was there, but there was so much more to this individual as a person and their background, that it is specifically our job to educate the prosecutor and the court about those circumstances, not as a justifications to the criminal conduct, but as a justification to the desired resolution that we have. Why is that such an important component in the criminal justice system, and how do public defenders specifically play such a big role in those types of situations?
Of course, it's crucial. I think most people at first blush think someone who commits a crime is somebody who is evil or mean or has this awful intent. And I could tell you, in doing this for so long, I can't really think of anyone like that. No one wants to commit crimes. No one wants to be in trouble. A lot of these things happen because of rough childhoods, because of circumstances out of our client's control. And we have to research that and investigate that and present that to everyone to kind of give them, an idea of who they are and how they ended up in this situation. Most of my clients have some sort of untreated mental health issue that has just never been addressed, where it could be anything from a bipolar disorder to post-traumatic stress to just depression. And it might be related to something traumatic that happened in their childhood. And it's my job at that point to present that to the prosecutor, to the court, to say, hey, listen, this person did not have the easiest life, and they were sort of put on track to be in this position. What can we do maybe to get them out of that? And one of the best things we have in our office are so many resources to help our clients now, between the substance abuse assessment unit, the downtown transition unit for mental health, our housing coordinator. It's amazing how far we've come in providing these resources to our clients, because we can come up with a better solution than just imprisoning somebody, or, as I have judges tell me at times, warehousing them like they're an object or a piece of furniture that we're just going to put somewhere for a while. That's really just kind of a throw your hands up, quick solution to the problem. And so if we can really find out who that person is, maybe we can find a punishment that helps them. I completely understand there needs to be some kind of punishment for certain crimes. I had a very, very bad stabbing several years ago, and I understand the prosecutor's reluctance to just say this person should not spend a day in jail, as the person that was stabbed had to have many surgeries. But at the same time, even my victim in that case did not want my client to face a lengthy prison sentence. They were both kids that had grown up in a gang-infested neighborhood. They were a product of their environments, and there had to be a better way to try to find the punishment that fits the crime. And so that required a lot of investigation into the physical abuse my client had endured, the neglect from his parents, the reason that he decided, you know what, the gang seems a lot better because at least they make me feel like a person and make me feel special, because I'm not getting that at home or school. And so when you put that information out there, that's how we kind of get to these plea bargains or these resolutions to these cases, where we're not just putting our arms up in the air and saying, well, they stabbed somebody for no reason or because they lost their temper, so now we need to put them in a adult-sized playpen for many years and then just let them get out and figure it out from there. It's really not the best solution. I hope someday we get away from mass incarceration, lengthy prison sentences for a lot of these types of crimes, where we can come up with much better plea bargains. I don't think it's better for society at the end of the day. People do not generally come out of prison after many years, for the better. I mean, some do, but that's the exception, not the rule. So we have to continue to be creative, because if we really want to put an end to crime, if we really want to limit the amount of crimes that we have, we can't just have those kind of answers where we just say, well, how much time should they serve? There's a better way we can do that. And one of the ways is we work with our investigators, we work with our team of clinicians, and we present that to the prosecutors and the bench.
Jason, I think you just perfectly summarized what this show aspires to do, what change we are focused on creating in the criminal justice system as a whole and the type of reform that I think that it's needed. I think you're absolutely correct in that it's really the role of the public defender or criminal defense attorney to bring more into the case than just a booking number or a case number. In my opinion, the prosecution and somewhat of the judges do their best to dehumanize each and every individual because I don't know if it makes their job easier or more digestible, but mass incarceration is not the solution and hasn't been the solution. And so I'm thankful for individuals like you and myself who continuously push back against that type of mindset and to inform the courts and the prosecution that there are individuals behind these booking numbers, behind these case numbers, and that you're absolutely right that it is the exceptions, not the rule, that people commit crime out of pure evilness and just disregard for human life. But the truth of the matter is, as criminal defense attorneys and specifically public defenders, there are going to be tough cases that you come across your desk. What's your opinion with regards to a public defender not being able to turn down a case that they're assigned to?
I take a lot of pride in that, and that's one of the things I really love about our work because it is a challenge. A lot of times I get asked by my clients, have I ever thought of going to private criminal practice? I did that as a litigation assistant in Washington State, and I had done private criminal law. And I tell them, I enjoy the fact that whatever case I'm assigned, I can't turn it down. When we were in private practice, we could turn down a case. We can turn down a certain client perhaps where we just maybe didn't see eye to eye on things. And I love that challenge, which is I have to work with somebody who didn't choose me. I have to work with somebody who maybe didn't trust me right away. And most of the time I'm able to gain their trust. Most of the time I'm able to have them understand that I'm looking out for their best interests. And even more so, I did not necessarily select to have this type of matter fall on my plate. So I have to figure out what I can do to defend them. We are very fortunate to have so many resources in our office and attorneys who have probably handled similar cases. So I get to have a wide variety of cases, but I take a lot of pride in that because I know for a fact there are cases that probably no private attorney would want to touch. And if no one else will do it, I will. And I will do it to the best of my ability, regardless of how bad the crime is, regardless of how difficult maybe the client is in terms of working with their lawyer. I will find a way. And I've done it many a times. I've had clients who've wanted to hurt me in the courtroom. And I can tell you, and I tell everyone this, our job is a results-driven business. And I could have a client hate me one day and then love me the next if we have a great result. I can have a client love me one day and then hate me the next because of the results. So it's always a results-driven business too. I try to remember that and keep that in mind in terms of how things are perceived as far as our job goes. I've had clients retain private lawyers and then afterwards say that they regretted it and wanted to come back to me and say it wasn't working out, because they weren't getting the result they wanted. I've had it go the other way around. I've had a client stick with me and not retain a lawyer, but maybe we didn't have the result they wanted, and then they were very upset and regretted not hiring a lawyer. So it's also a results-driven business, and I try to keep that in mind that, the way you're usually perceived by the client or their family, it's what was the final outcome on the case? But the majority of the time, Lucas, people are very happy with the work that we do and the results that we get. And I enjoy that challenge that right up front, out the gate, they are very skeptical of us. They think that we work with the government. They think that we work for the DA. They think that we work for the court. And so I enjoy that challenge to convince them otherwise.
I couldn't agree with you more. I actually love that component of the job. And there's two reasons, me personally. One, I think it makes me a better lawyer because it's now outside of my control the type of legal issues that I'm confronted with that I then have to go and do legal research for. Thank God I have you to go and confer with that on, because otherwise I wouldn't nearly come to the research answers that I would need to, but for that. And so I just think that it makes you a better lawyer. Like you said, it forces you to overcome trust issues with clients, perception issues with clients. And there's a lot of adversity that it just builds a lot of professional grit that I've come to really appreciate. And on the other side too, I think it also has made me a better person. It's made me more sympathetic and empathetic. It's widened my perspective. One of the things that I think is so absent from the criminal justice system is perspective. One of the things that I love to highlight is the old example of there's an individual who gets on, a train or a subway or trolley, and he has two rambunctious kids who are just running up and down, causing mayhem and havoc. And there's a bystander on that transportation system who looks at the father or the parent and says, "Hey man, like, get control of your kids." And the father looks at that individuals and says, "I'm sorry, their mother just died and we don't know how to grieve, and I don't know how to tell them." And I think that just resonates so true with the criminal justice system, as you indicated, again, in your example of the TED Talk, of people who find themselves in horrible, horrendous situations and crime. There's always different perspectives as to how that happened, how they got there, why it happened. And that's how we're able to get all of the various results that we get. Maybe it's a guilty verdict, but it's a better sentencing than what the prosecution was offering. Maybe we beat some charges, but go down on other. Maybe we get the full acquittal. And so I've really come to appreciate that aspect of not being able to turn down any cases. On the flip side of that, do you ever find yourself wishing that there were cases that you could maybe cherry pick to move forward?
Well, there's certainly days where I do. I feel like some months I'm assigned very, very difficult cases with very few avenues for a legal defense. And for whatever reason, throughout my career, it's really been feast or famine. I'm either in trial a lot or I'm in trial very little. Since COVID, I have not tried nearly as many cases, but there was a stretch in 2 years where I had done 20 jury trials, and I was very happy with it. I was going back to back. I was in a trial picking a jury while I was waiting for a verdict in the previous trial. So the judge and I would take a break to go answer jury questions with our previous jury while we're picking another jury afterwards. So there are points definitely in my career where I think I'd like to maybe say, all right, can I just get a real basic kind of a stolen vehicle case right about now, because I cannot try any more cases of domestic violence or with child victims. There was a stretch for a while where I had to cross-examine, kids essentially. And when I say kids, ages from 9 years old, 8 years old, 10 years old. And they were not always necessarily the victims in the case, but they were recipient eyewitnesses. And so they were very important to the case. And so I had to cross-examine all of them. And so there was definitely a stretch where I said, I don't want any more child witnesses on the stand. So I'm not cross-examining kids. I could use some kind of a variety. But that's another challenge I do enjoy, is being able to cross-examine a difficult witness or question a difficult witness. I certainly enjoy the challenge of that. But there's points in my career where I've definitely said, all right, can I get some variety? Can I get a break here? I had a period where I just had so many violent crimes in downtown of just assaults and fights. I was like, can I please get a case where people are not hitting each other with certain objects and I'm arguing over self-defense. But, at the end of the day, it all worked itself out. I enjoyed it. I have no regrets looking back. Certainly, I've never passed up a case and said, I cannot handle this case. I've certainly taken cases on from my colleagues when they've had personal issues and had to be out of the office. And I've had no problems doing that as well, no matter how difficult the situation. I've been appointed to cases and had to try cases where the client lost their pro per status. They were representing themselves, and for whatever reason, the judge had revoked their ability to represent themselves. And I come in last minute, and the client is not happy because they want to represent themselves and immediately want to fire me. And I was more than happy to take on that challenge as well. So There are definitely times where I feel like I could use a break. There are definitely times where I'm like, hey, I'd like maybe more cases to try. But at the end of the day, we can't pick and choose what we get. And so for as much as that may be difficult at times, it doesn't outweigh the good that I just enjoy getting whatever comes my way, taking on whatever challenge comes my way. And one of the biggest things is something that maybe at first glance doesn't look like a great case, it turns into one. And that's one of the best things. Sometimes a case that looks great, it gets bad very, very quickly. So you can never really tell out the gate either.
I think that we've done a great job of highlighting the importance of public defenders and the role that they play in getting prepared for this episode. I was scouring the internet of, most common questions that people have for public defenders. And the one that I kept seeing come up the most, and in a weird way, this might be a loaded question, but at the same time, I think it would just kind of depend on what your definition is. And one of the things that I kept seeing, especially knowing that as public defenders, I've really honed in on the fact that with each and every case that we get assigned to, the expectation is that we're supposed to lose. And I'm okay saying that, because at the end of the day, I think that if the police do their job correctly, if the prosecution do their job correctly, as well as the judge, then the way the system is supposed to result is a conviction. Thankfully for us, that's not always the case. And as we've highlighted, even when the jobs are done correctly, there's still another side to the coin that needs to, or part of the equation that needs to be inputted, which is the fact that, again, there is an individual on the other side of that case. But, how have you come to define winning as a public defender? And with that definition, would you say that public defenders win? Because I think to society, most of the time, we don't. And I can tell them personally, I disagree with that.
100%. Winning is the easy part of our job. Nothing better than a not guilty verdict. File is closed and it is done. And I can put into our case management system, acquitted. I wish the client well. Maybe I might have to get their property returned to them afterwards if that's an issue. But aside from that, there is very little work left. The challenge becomes afterwards. Let's say you do have a guilty verdict and then the case needs to be appealed. There were problems in the trial. You have to continue to fight. So perhaps you lost a trial, but there are things that the appellate attorney needs to know to have the case overturned. I've had that happen. And you can't give up the fight. So you sort of redefine your definition of winning. Getting a guilty verdict at trial, perhaps the trial was unfair. Perhaps the judge made very poor rulings. Perhaps the prosecutor did things they were not supposed to do. You have to continue. You have to keep going on. And then you have the case maybe come back on appeal. And now you plea bargain the case afterwards for maybe something better or a better deal because the prosecutor decides it's not worth trying again. Maybe you try it again, but that could be seen as a loss to people. They would just say, well, you had a guilty verdict at trial. Another time, maybe you could be seen as having a loss as your client is facing however many years in prison on certain charges, and you argue to find guilty on others. And you could say, well, your client got convicted of 2 charges. And you could say also, well, they were found not guilty of 8 of the charges. And the 8 charges they were found not guilty of, they were facing like 50 years. Now they're only going to get 3 years. So that's way better than 53 years or 55 years, or whatever the sentence could have been. So you do redefine your definition of winning. Sometimes also, you're able to maybe get a very favorable plea bargain you never thought you'd be able to get. You have a client facing a life sentence and you're able to get them probation. I had a misdemeanor offer on a case where their client was facing 35 years to life, but at the end of the day, he pleaded guilty. So maybe to some, they'd say, well, you lost. Well, no, I didn't. We could have gone to trial and run the risk, but what kind of lawyer am I if I tell the client, hey, you know what? Just take that chance. You could walk out of jail today with a misdemeanor battery, essentially hitting another person. Or you know what? Why don't we just go to trial and fight it? And that brings up another point, which is, would you ever have somebody plead guilty who maybe didn't do it? Yes, absolutely. And that would be a perfect situation where, do you want to get out of jail today? Or do you want to maybe risk spending the rest of your life in prison and it's not worth it? That's my advice. The client ultimately makes the decision, that I will tell them, don't mess with your life. You'll sit here in the courtroom spending more time with me worrying than you will right now just saying the words guilty to a minor crime. So those kind of things happen. But that could be seen as a loss to people. They'll say, well, your client still got a conviction at the end of the day. You should have just gone forward and fight it. And, it's like, absolutely not. No way. The risk involved is not worth it. And that's a big part of our job, is making sure the client is aware of the risk. They know the risk that they're taking, and is it worth it? And if you mitigate that risk and you end up working it out in a way where it's not worth taking that risk, and the client understands that, that could be a huge win as well. So, how many times do we have cases, Lucas, that a client's facing like 18 years and like 15 years and 12 years? And it's like, hey, listen, take the 2 years right now. You'll probably serve maybe another, year or so, but you'll be done with it. And it's just not worth the risk. And the client usually agrees and says, okay, that could be seen as a loss, but maybe you had to really fight for that. Maybe you had to bring in other witnesses to put doubts in the prosecutor's mind. Maybe you had to present mitigation about your client to get there. That could be a really big win for you. You didn't get a straight not guilty verdict, but at the same time, you beat what the client was facing. You beat the risk of them doing a lot of time. You beat the risk of them ruining their life by spending it years and years in prison. So you sort of redefine what winning means. And winning is easy. Nothing better than a not guilty verdict, but the real challenges are everything that happens in between.
And I think that highlights such an important issue too, is that I think so much of society and those from the outside looking in see the criminal justice system in absolutes. You're either guilty or you're not guilty, and there's little and few far between. Whereas those of us who are in the trenches, we have to redefine our definition of winning, because as you excellently highlighted, there's different magnitudes of it. Not every case is about getting that full not guilty or that full acquittal. There's different components. It to me, winning goes back to your result driven business. If the client is happy with the way that the case resolved, like, that's a win. Like that's our goal, is customer satisfaction first and foremost, and that the law was upheld. So I think that those were just super great points, and really go to the answer of, I think most public defenders would say that they are winning, not even necessarily on a case-by-case basis, but as a sense of justice. So, we're winding down the interview. There's just a couple more questions that I want to ask you. And, as we've talked about, and as you highlighted in your TED Talk, the goal of defending the indefensible. And we've talked about how the criminal justice system isn't always fair. How do you see, or what do you feel the importance of public defenders are in that equation of defending the indefensible, or in the criminal justice system as a whole?
Well, the majority of people cannot afford to pay for a lawyer, or they can to an extent, and they eventually run out of money. And without us, who else is going to do it? They need that. I explained to the clients, your tax dollars go toward the courthouse staff. They go toward the judges. They go toward the district attorneys and the attorney generals and the police department. Shouldn't part of your tax dollars also go toward your defense? And so we need that. We need it because so much of the public funds are going in the opposite direction. Why is it that the person has to go into their own pockets to pay for a defense? And so that's why it's so crucial that we come in here. I tell my clients, you could certainly retain an attorney, but you'll have to pay to talk to them. And there's nothing wrong with that. I mean, I have plenty of friends who are private attorneys, and I did that. They have to get paid. I mean, they can't just make money come out of thin air, but you have to pay to speak with them or consult with them. You have to pay for their court appearances. If you want them to have an expert, you may have to pay for that as well. I know sometimes attorneys, private attorneys, can ask the court for money, but sometimes the client has to pay for that or pay for the investigator. So if you come to us, it's no charge. I have an investigator that works for me on your case. It's free. If I need to consult with an expert, it's free for you. Now, obviously, it's not free in the grand scheme of things. It does come from tax dollars, but isn't that fair when we look at it in a way where all the other public funds are going in the opposite direction, to the crime lab to prosecute, to the district attorney's investigators to help prosecute, to the sheriff's department and the correctional staff in our jails to essentially guard these people while they're incarcerated? A lot of that money is going elsewhere. There should be some that goes toward defending them. And that's why it's so important for us to be there, because if we don't do it, Who will? The majority of the people, especially charged with serious crimes and felonies, cannot afford to pay their own legal representation. So we have to be there for them. Otherwise, this whole team, this whole opposite side of the system, they're going to be outnumbered and overwhelmed.
Yeah, I mean, I've always said that, given that like 4 of the first 10 amendments in the Constitution, in my opinion, relate specifically to criminal defense, the 4th, 5th, 6th, and 8th, I couldn't agree more. I absolutely think that there needs to be more money and more funding in there, and not to necessarily fill mine or other public defenders' pockets. I think all of us do it. None of us are in it for the money, and having that quote unquote free component in our cases, I think is a gift, because it eliminates this financial struggle component that, no question about it, has ended up costing people cases, unfortunately, because they weren't able to afford that extra hour of the attorney's time. They weren't able to afford that expert witness. And so I couldn't agree more with that point. Jason, I really wanted to thank you for giving us the time this morning. I think you've just highlighted some outstanding points in the true essence of why we do what we do, and the importance of defending what others would see as the indefensible. Here on Members of the Jury, we embrace taking matters to the box, whether that's in the courtroom or on a TedX talk. But I want to ask you, as we do every guest, what's the significance of taking matters to the box mean to you?
It means to fight for something when everyone else is looking at you and telling you you're wrong, or when everyone else is looking at you and telling you that they don't agree with you or believe you. So that's what taking it to the box means to me. You cannot be scared over peer pressure or public pressure. Sometimes when you were mentioning take it to the box too, I'm thinking about maybe that one juror when there are 11 people in the opposite direction, and that one person says, no, I'm willing to take the time, and I'm willing to be that voice in the room that stands up for everyone. And Lucas, in our work, I mean, it's natural, and sometimes it happens to us. You read so many police reports and you see so many things that it can grow cynicism inside you, and we can't ever allow that. And so we take it to the box, because we will not be a cynical mind. We're going to be an empathetic, open mind, a diligent mind, and a hardworking one in the face of opposition.
Well, we're so glad that you took your matter to the box, that you educated the masses on what we do, and we continue to appreciate you for what you do on a daily basis. So thank you so much for giving us your time this morning, for educating our members of the jury, and continue to take matters to the box. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.